I think that's just about started. So good afternoon. Welcome to this information session with Citizens Advice Liverpool, the EUSS project, and Migrants at Work. Welcome to this online session. Thank you very much for joining us. We're really glad that people are taking an interest and joining us in these sessions. For those who've just joined, we are recording the session and we're hoping that we can put it on YouTube later on, so you'll be able to share it with anybody if you find that it's very interesting. We've had a few questions in advance. I think most of these we will be able to answer during the presentations, and we will also go back to them later on. We will switch off recording when we come to the Q&A session, and then it would be lovely also to see people switching cameras and microphones on. So first of all, the EU Settlement Scheme project at Citizens Advice Liverpool is grant funded by the Home Office to help people, ideally people or primarily people in vulnerable situations, with making the applications to the EU Settlement Scheme. The application to the EU Settlement Scheme is done using a mobile phone app to scan an EU passport, and then continued on the website. Clients or applicants have to provide evidence that they are, first of all, of course, an EU citizen and resident in the UK, so that to show that they are eligible to apply to the scheme. And then they have to apply to either pre-settled status if they've been resident in the UK for less than 5 years, or settled status if they've been here for more than 5 years. For anybody just to let you know, we're recording the session and we hope to put it on YouTube later on. So if you don't want to appear in the recording, please do switch your camera off just while we're recording. We'll stop recording when we come to the Q&As. And anybody who is visible or audible, I will ask for a video consent form so that we can put it on YouTube. So I don't know, Jennifer, if you want to appear on the recording, that's absolutely fine. Jennifer is actually one of our colleagues at Citizens Advice Liverpool. I will send you a link for the video consent form. If you could fill that in for me, that would be brilliant, so that we can put it on YouTube. So yes, I was just going over the project here at Citizens Advice Liverpool. The EU settlement scheme, of course, became necessary because of Brexit. Until the end of the transition period, until the 31st of December 2020, all EU citizens could exercise the treaty right to free movement and live and work unhindered in the UK and didn't need to get any kind of immigration status or apply for anything. Anybody who lived in the UK, was resident in the UK on and before the 31st of December 2020 is covered by the withdrawal agreement and has certain rights afforded by that agreement. Anybody who came to the UK from the 1st of January 2021 onwards is under new immigration rules and can no longer rely on the treaty right to free movement. So, as I've already alluded to, there was a transition period from Brexit Day until the 31st of December, and there is now a grace period until the 30th of June. And on the 30th of June, the EU settlement scheme will close to first applications. It will still be possible to make a late application. It will still be possible for family members to apply to join the EU family members who live in the UK already. Obviously, newborn children will still have to be registered on the system. So it closes, but it doesn't quite close. It will still exist and it will still be a thing and still be possible to make applications. Our grant funding runs until the end of September. So we currently have 3 project workers who work on this full time. After September, of course, our wonderful volunteers, such as Jennifer, will still continue making immigration applications, including applications under the EUSS rules. And it's, of course, very important to stress here, with just about a week to go, that the deadline for making applications is the 30th of June, next Wednesday. Get your application submitted. It's really important to have it submitted, ideally before that date. Additional evidence can always be added later. Until the 30th of June, this evidence is my right to work in the UK. But from the 1st of July onwards, employers will be expected to check for the right to work of new recruits, people who are newly starting with them. And there is a new digital system for doing this. So when you've been granted a status under the EU settlement scheme, you do not get a proof of your status. There is no stamp in your passport, no sticker in your passport, no electronic card. It is just a digital status, and this is checked by going on a website on .gov.uk/view proof immigration status, entering the passport number or the identity card number of the document you use to make the application and your date of birth. And then you get a two-factor authentication security code, either to your email or to your mobile phone number, the one used when you made the application. If you've changed it in the meantime, hopefully you've only changed one and not both, because you have to go to a different website to update it. And updating both takes several weeks. Updating one can be done in just a few minutes. So once you've logged in, you then see your picture that was taken during the application process. And from there, you can generate a share code, which you can then email to either an employer or landlord or NHS or council or whoever you're having to prove your status to. So for the digitally literate, this looks like a generally workable scheme, excuse me, and fairly straightforward. And for most people, it is. However, there are a lot of people who are not all that digitally literate, or not even all that literate in multiple languages at all. So even if they are perfectly capable of speaking 2 or 3 languages, that doesn't mean that they can read or write. And it doesn't mean automatically that English is amongst those languages that they know sufficiently to understand the legal terminology used on the websites. Elderly people, of course, don't necessarily know how to work a smartphone. Sometimes people are disabled, or they might have dementia. People who have fled domestic violence very often have no documentation. So maybe they were never actually listed on any bills. They might not have had a bank account in their own name. So they might not be able to provide any additional evidence if it's requested of their residents. And sometimes they might even have been prevented from renewing their passport. Passport renewal is also not exactly cheap. So if people have fallen on hard times, they might not have been able to renew their passport. Their passports might be lost or stolen. There might be a lengthy process to retrieve a birth certificate, to get a new passport, and so on. So just today, for example, I submitted, literally 5 minutes before we opened this call, I submitted an application of a client who's been known to me since July 2019. And it has taken until now to get this sorted out, for the simple reason that his passport expired in 2016. His country of origin requires proof that he has not naturalized in the meantime in the UK, because they do not allow dual citizenship. There's a cost attached to that. He also didn't have his birth certificate, so he's homeless. He doesn't have the money for £157 for the passport, plus £350 for the form from the British Home Office to prove that he's not naturalized, plus travel to the embassy in London, plus, I mean, this is small fry, £6 for an extract of the birth register in his town of birth. So thankfully there was a charitable organization from his country of origin that was able to help him, and they've been really wonderful and provided several hundreds of pounds to help him with securing a new passport. When he renewed his passport, finally, after a long journey already, his country of origin noticed that it was damaged, and because it had been expired for so long, they had to send it off to their own Ministry of the Interior for checking to make sure that it had not been tampered with and faked in any way, shape or form. So that added another delay, and finally he received his passport last week, and we were able to book him in for an appointment today. And had another little delay while he ran back to his house to get his national insurance number, because you can enter that in the application, and then the system can check with DWP and HMRC computers. So as you can see, it's not always a straightforward journey. A lot of people are not necessarily aware that they have to apply to the EU settlement scheme. They think that they might be exempt because they've been here for a very long time. I've lived in the UK for 33 years. I had to apply to the EU settlement scheme. I'm married to a British citizen. I am the mother to 2 British citizens, and still I had to apply. However, sometimes people think that they don't have to apply because they've been here for so long. They might have, or they feel and they think that they have automatically acquired the right to be here, and that is also true, but there is no proof of it. So the EU settlement scheme enables us to get, albeit only a digital proof, not a physical proof. We are finding a lot of problems at the moment with people realizing that children have to apply independently from their parents, so they're not covered by their parents having made an application. So there are a lot of people scrambling to make applications. In fact, this morning when I filled the application in, I had to wait in a queue, which only happened at other really, really busy times, such as just before Brexit Day, just before the end of the transition period. So at the moment, a friend of mine who works in the Home Office has informed me that they are receiving 10,000 applications per day. Who knew there were so many EU citizens living in the UK? None of us knew. There's about twice as many as we expected, but there you go. The Home Office has granted about 5.4 million statuses, but there are around 340,000 people still waiting to get their status outcome letters. So that's it in a nutshell. The deadline to make applications is in, where are we now? 6 working days, next Wednesday, the 30th of June. And I'm going to hand over now to Ake Achi from Migrants at Work, who's going to tell us more about how the right to work checks are changing with July, and also some of the problems this presents and the changes to immigration laws present for employers and employees. So over to you, Ake.
Thank you, Cozy. Thank you very much for that. I'm just going to try to share my screen. How do I do that? There you go. Okay. Can you see my screen? Yeah. Can you see my screen? Okay, great. Hi everyone. So my name is Aki Achi. I'm the director and founder of Migrants at Work. So I'm an EU citizen as well. I'm a Black EU citizen, as you can see, and the color of my skin make a lot of differences really when we talk about a right to work check. As Cozy has well said, employer has to carry out the right to work check. The issue with that is there are several problems. So the first problem employer has to deal with is the illegal working offense. The second one is the legal employing offense. And sometimes there is a confusion between the illegal working offense and the legal employing offense, but we will come to that. The second one is the race discrimination offense as well. So you have labor exploitation and false labor exploitation. Again, these two terms are completely different as well. Labor exploitation is a civil offense; it's not a criminal offense. False or compulsory labor exploitation is a criminal offense. So, in terms of the right to work check, how employers should perform the right to work check. What you have here is currently it is how it is working. The right to work check is working, but we're not going to go through everything. But you have different online tool. You have the employer's guide to right to work check. You have a digital platform here. You have another one here. So you have several platforms for employers to begin the right to work check and then to end with the right to work check. But hopefully, what the government's saying is that by putting an online checking service, then it's going to make life easier. In a way, it is correct that it's going to make life easier technically for employer to do the right to work check. But in practice, it become a little bit difficult because the system itself is not fit for purpose. It does not, it makes a lot of mistakes. So, what I have included here is the landscape of immigration law at work. Again, I'm pretty sure it's a little bit too small so you guys can't see it, but I put those different color for you to see how complex it is when you mix EU citizen, family member of an EU citizen with non-EU citizen, with refugees, asylum seekers. It become quite complex for employer to understand. So using only the online checking service system is not going to help employer at all. In fact, it create more confusion than anything else, which lead then to labor exploitation, discrimination, and victimization, or these kind of offenses in the workplace. And this create, of course, a racial tension in the workplace where somebody is refused. If somebody is refused the right to work check, so the right to work, following the right to work check, immediately people think about discrimination. When in fact, in practice, it may be discrimination, but the individual, the manager who performed the right to work check may not necessarily a racist person, but it's just that the process lead to discrimination. So before getting into the right to work check itself, it's really to understand the legislation around the right to work check. So the Immigration Act 1971 is the general principle of immigration control. So this provide a framework for immigration control and decide who is subject to immigration control or who is not. So once you have determined that, you need to find out who has the legal right to work. So for that, so the first point is if you had a right of abode, then you're not subject to any immigration control. Therefore, you can work in a country without any restriction. But it's not always easy, as we've seen with the Windrush scandal. People had a legal right to work and to remain in the UK, but they cannot prove that. If you do not have the right of abode, then you need permission to work. So if you're an EU citizen, you still need permission to work because you are in the UK, you come to the UK to work. So for example, post Brexit, all EU citizens who are coming to the UK then will be subject to Immigration Act 1971. They would need to have permission to come to work in the UK. As Cozy said, there is no longer freedom of movement. So once you have the permission to work, it does not stop there. You need also some condition. So your immigration status comes with condition, and you need to meet those conditions to be able to work. So, for example, if you have permission to work, you have applied for a visa after Brexit, after the first, from the 1st of January, and you come to the UK to work as a nurse, for example, and then you have a lot of bills and you want to do an extra job, you find a delivery job, for example, and you want to do a few hours per day or per week, but this is not part of your immigration condition. And you came here as a nurse, but you want to work as a delivery driver. If you do that, then you will be in breach of your immigration conditions, so which means your visa will be canceled. Um, the other issue as well is this will be applicable to EU citizen now, but under the Immigration Act 1971, if you have the legal right to work, you're in the UK with a visa, but your visa has expired and you have extended your leave. Then what we call Section 3C leave. This extend your leave while the Home Office is assessing your application. So even though the Immigration Act 71, a Section 3C leave, does not apply to EU citizen, you have the equivalent of Section 3C leave under the citizen temporary protection. Okay. So once all the above applies, so if you have permission to work or if you have right of abode, then that's fine. You shouldn't have any problem. If you have permission, if you have the condition attached to your permission, then you shouldn't have any problem. You have the legal right to work. You have the statutory right to work in the UK. So now proving it is a never matter. So that's the first legislation that we have to take into account. Then we move to the second one. So this is the Immigration Act 2006. So what Immigration Act 2006 does, it's a secondary legislation. So the 1971 is a primary legislation. So the second legislation is really important because whatever right you have here, these right here under the what a provision of this legislation says cannot cancel your right to work, your right to work you have here, cannot repeal your right to work, or cannot do anything. So what the section 15 of the Immigration Act 2006 says is that an employer have to establish a statutory defense against illegal working. So employer cannot employ somebody who has not been granted leave to enter or to remain in the UK. So that's the first thing. So if you don't have the right to be in the UK, then you don't have the right to work. If you have the right to be in the UK, it does not necessarily mean that you have the right to work. This will be subject to your permission and the condition as well. Or if your leave to enter and remain in the UK is invalid or has ceased to have effect or is subject to the condition, as I said earlier here, to the condition here under the Immigration Act 1971, then employer will not be able to establish a statutory defense. Okay, so that is really, really important. So that's what an employer has to do to establish the statutory defense. But it's the statutory defense against illegal employing. It's not against illegal working. So when does the employer commit a criminal offense? So the employer commit a criminal offense if they employ someone who they knowingly know is disqualified by reason of the immigration status. So if your employer decides to employ you, but you don't meet these criteria here, as I said, right overboard the permission or the condition, then in that case, they would be committing a criminal offense. But if you're a EU citizen, for example, and who has submitted a valid application, but the employer cannot obtain a document to confirm your immigration status, but because you have applied but submitted a valid application, you still have the legal right to remain in the UK. The employer therefore is not committing a criminal offense. But many employers sometimes will say, well, you can't prove your right to work, so therefore there's nothing I can do. I can't keep you at work. That's the problem the challenges employer are facing under this legislation because they cannot obtain the document to prove immigration status. So they will think, well, you don't have the right to work. So once you've been through these two pieces of legislation, then you move to the next one, which is the Immigration and Restriction on Employment. So there was a first order in 2007 and the second one 2014. And so you had another one in 2018. So we're not going to go through all this, but what this does is it tells the employer what kind of document are acceptable for you to prove, well, for employer to establish a statutory defense. So those documents, so for example, some of those documents include, so a valid passport, for example, or you could have had a combination of valid passport plus national insurance number, a different document. So if you do not provide all these accepted document under this legislation to the employer here to establish the statutory excuse, the employer will say, well, this is what I'm asking to give me. You don't have that. Therefore, here under this legislation, I cannot employ you because if I do that, then I will be in breach of this immigration act. But that is not always true because if, for example, you are a EU citizen who's been in this country, submitted a valid application under the EU settlement status, but you haven't yet received that yet, and the home of the employer's guide to right to work check, which basically bring all these documents together for him to help employer would tell, for example, you need a permanent national insurance number to work for employer to establish statutory defense. But if you don't have that national insurance number, it's irrelevant. because it's not part of the element really you need to determine your your immigration status in this country. Your national insurance number, anyone can work with a national insurance number, but this is an obstacle for employer to employ somebody. So once you went through all these free legislation, so you have the legal right to work, the employer want to establish as your defense, but they're not too sure about how to do it. They're asking you for the document. You can't provide the document, then they decide that, well, because you don't have the document, they want to terminate your employment. So in order to terminate your employment fairly, so there are three different options, I would say. So the first one is the employer can terminate your contract if you're in breach of any other legislation. So in this case, we're talking about the statutory right to work. So if the employer cannot provide, if you cannot provide evidence listed here, but you still have the statutory right to work, and the employer decide that, well, I haven't been able to establish statutory defense, therefore I can't employ you under the legislation. But that would be wrong simply because you're not breaking any law. Because the law, as I said at the beginning, the Immigration Act 1971 says that you need either to have the right of a border permission and condition. If you have these permission and condition, but you can't prove it, you're not breaking the law. The employer simply cannot establish a statutory defense. So if the employer, sometimes the employer realized that you had a legal right to work, but you can't prove it. So they are using this provision here for some over substantial reason. So for some over reason, they think that you don't have the right to work. And generally is because you haven't been able to provide these kind of evidence. But that's what often get employer into trouble because they end up in court because of discrimination. The other element is the employee's conduct. So, for example, you have submitted your application, you can provide the document, and your employer will ask you, please contact the Home Office. We need something in writing to confirm your immigration status. But you will say to the employer, well, I contacted the Home Office, they gave me the certificate of application. That's the only document I have. But the certificate of application is not listed here under this legislation here, under this order. It's not listed. So you're gonna have email going back and forth between you and your employer asking you to provide information you cannot provide. So potentially they can also dismiss you on the basis of your conduct, which is completely wrong. But this happen all the time. So once you've been through all this legislation, you've been arguing with your employer decides to dismiss you and everything, then you end up with a discrimination claim. The problem with the Equality Act 2010, for example, is that so there are several protected characteristics, but immigration status is not a protected characteristic. But of course, immigration status is linked with the nationality. Then potentially that where you could have a claim for race discrimination on the ground of your nationality. So when things like this happen, so it's not always easy. You often need a lawyer to be able to help you with that. So you have two elements in terms of a discrimination. So you have direct discrimination or indirect discrimination. And what employer often do is that they will conduct the right to work check on the entire workforce. But the reason why they are doing that is to identify those individuals, those foreign nationals who do not have the legal right to work. So by doing that, they are targeting not a foreign national. And in some of the document we have seen where we you have employer targeting EU citizens, asking them to provide evidence of their EU settlement status. So clearly, they are indirectly discriminating against EU citizens. Again, this is another difficult area where you will need a lawyer to be able to challenge employers. So now, when we come to the case of the EU citizen, as Cozy said at the beginning, so she has given several sort of information on that. But the key legislation that protect the right to work of the EU citizen are the EU withdrawal bill. So all right are guaranteed under this bill. The EU UK free trade agreement as well protect our right, and the EU temporary, the citizen temporary agreement also guarantee our right during the transition period, but also after the transition period. So the debt occurs again the day earlier. So if you have applied before the 31st of December 2020, 11 p.m. UK time, I'm sorry, if you've been in the UK before the 31st of December, and if you have applied before the deadline, the 30th of June, it doesn't matter whether ideally it would be good to have your status before the 30th of June. But if you don't have that confirmation before the 30th of June, because what you just have when you submit your application, you just have received the confirmation the application, the certificate of application. So once you receive that, these confirm that you have submitted your application. So during that process, it doesn't matter whether it takes 3 months, 3 years, because of the delay, it might take a long time. But whether it take a long time or not, you still have the legal right to work because that's what the temporary agreement, the temporary protection agreement is. It protects your right. So until the 30th of June, the current right to wear check process is that the employer has to check physically your ID. So they check your passport or your EU national ID card. They look at it, whether it is valid. They make a copy, and they have to do the check right in front of you. But after the 30th of June, it's only um, online right to work check. The problem with the online right to work check is that so what you the first step you have to do is to first check your immigration status yourself. And because he explained the process earlier, the problem is that the system sometimes fell. And when the system fell, then you are unable to provide that evidence to your employer because the system does not recognize your immigration status and you don't have a backup system. The physical document does no would no longer exist. So how can the employer prove that you have the legal right to work? That is really, really challenging for employer. And I'm not aware of any backup the Home Office has put in place. Of course, you can ring them to, for the employer can ring them to double check. They can ring the employer checking service to double check your immigration status for the confirmation. But in the meantime, the employer will not employ you. So even if you have the legal right to work, you can't work. So you still have to pay your bill or things like that. But the employer does not want to take the risk. And that is challenging for employer. So if you are an existing employer do not have any, there's no legal requirement for employer to carry out a mandatory, there's no mandatory requirement for them to carry out the retro, ret, sorry, the retrospect, can't pronounce this word. Anyway, there is no requirement for them to carry out the check while you've been working for them, if you've been working for them before the 30th of June. But in many of the cases we have seen is employer don't really care about that. They really want to carry out the right to work check, the retrospective right to work check. It does not matter whether you have been working for them before or not. They still want to do it. And the reason why they want to do it is because they want to make sure that you have the legal right to work in the UK after the 30th, after the 30th of June. But they will maintain a continuous statutory excuse against civil penalty in case it turned out that you did not have the right to work. So let's say, for example, you have submitted your application before the deadline, and then 2 months, and the employer employ you for 2 months or 3 months, and your application has been rejected. Then during that period, you had the legal right to work. But the employer do not want to take the risk So that's the reason why they've been asking EU citizens to provide evidence of the EU settlement status before, or for them to keep you on after the 30th of June. But this request is unlawful because they cannot do that, request that document, because during the transition, during the grace period, you still have a legal right to work. So employer has to be really, really careful, because many of them, we have seen this document where some employer, sometimes by providing immigration information, they at the same time providing immigration advice to the employer, which they're not allowed to use. They have an exemption, but that exemption does not cover them to provide immigration advice. And that is really, really important. But of course, no one want to challenge the employer. So the difficulty is for them, when you receive a pre-settled status and when you have a settled status, for the employer, it's quite challenging. It shouldn't be, but some employer believe that because you have a pre-status, therefore you have half employment right. It's only when you have the complete status that you have your full right, and that is wrong. We have seen cases with non-EEA where employer would adjust your contract of employment to match your immigration status, and of course it's illegal, but many employers are still doing that. When you have a certificate of application, it means that you have submit your application to the Home Office. So, and again, your right to work are protected under the temporary citizen agreement. But many employers do not want to accept that. So, as I said earlier, if you have submitted your application and it has not finally been determined, then your right are safe. But employers sometimes will suspend you or dismiss you. And of course, this is unlawful because during that period, you still have the legal right to work. What they will also do, so what they will refuse to employ you, so they will deny you equal opportunity because you have your certificate of application or you have your pre-settled status, but they're not too sure whether they can employ you. So this again will potentially fall under the Discrimination Act, but this will depend also on how the employer are doing the right to work check or are requesting those information. So they might, ask everyone within that organization to provide the confirmation of their right to work. But again, by doing that, what employers are simply doing is they're simply targeting a citizen, because if you ask all your workforce to provide their right to work, British national are not subject to the same rule. So therefore, in a way, you are targeting foreign national again. So when do employer establish a statutory defense? With the online right to work check. Once you have checked your own immigration status and you have shared the code with employer, so you check your immigration status, you see that you have the legal right to work. Let's say you print off this document and you give it to your employer. Even if he said on that document that you have the legal right to work, the employer will not establish a statutory defense against illegal employing because they have to follow the Home Office guidance. But then also have to share your code. So it is only once you have shared your code with an employer, and then the employer has carried out the verification on their own platform, that they would establish a statutory defense against illegal employing. But it may happen sometimes, as we've seen with the case of non-EEA citizen, that the Home Office fine employer because the employer did not carry out the right, did not go through the right procedure when they carry out the right to work check as recommended in the employer's guide to right to work check. But if somebody has a statutory right to work and the Home Office has fined the employer because they did not go through the proper right to work check, it's irrelevant because your statutory right to work is still in place. So we have seen some email, for example, from the Home Office to some of our service user where the Home Office confirmed that the individual's right to work has not been withdrawn. However, they could not work because they were not able to provide evidence of their right to work evidence of their right to work. So the physical evidence. And that is wrong because if you have the statutory right to work, it does not matter whether you can provide the evidence to show it or not. You have the right to work in the law. But of course, you have to provide that evidence. But when you are a citizen who rely only on the digital status, and if it's not working, then how do you prove your right to work? So that's where the difficulty is really. So in terms of your national insurance number, so you still have a lot of employers who do not employ a citizen because they don't have a national insurance number. Again, this is irrelevant. You can work with a national insurance number. What is also important to understand is that employers, because they believe that, so they have the statutory right to obtain information from you to establish statutory defense. But because of that, some employer believe that they can do those checks without complying with data protection. And you have many of these online app, for example, which employers sometimes are using to do the right to work check. And many employers are using that without the employee knowing that they are sharing the information with a third party, another organization. So by doing that, employer is potentially breaching data protection law. And that is really, really important because there is no legal, and also what is really important, the employer also sometimes share your data, your information with the home office. But there is no legal requirement for the employers to voluntarily cooperate with the home office. And what we see is that sometimes employers, because they do not want to take the risk, if they do the right to work check and they are not convinced that you have the legal right to work, then they phone the home office. They use the home office hotline. They advise the home office that has somebody does not have the legal right to work and blah blah blah, even if it's not always true. And as a result of that, we see the case with non-EU citizens where non-EU citizens have been detained because employer has carried out the wrong right to work check or obtained the wrong information, and as a result of that, advised them the home office, and they were detained and dismissed and detained. But then after the verification, they've been released. But it is a shock to the individual when you have the legal right to work to be dismissed and then to be taken to detention by the police or the home office simply because your employer did not understand the right to work check process. The common error employers are making is, so this is what I have included here is a cold case where the employer arguing that, so it was a family member of the EU citizen. So the employer were arguing in this case that that person has submitted an application and had evidence of a certificate of application, but that certificate of application is not listed on the list of acceptable document. So the employer would not employ that person. So that was the argument. I cannot employ you because you do not have the acceptable document. And what the employment tribunal said in that case is that that is not the law. There is no requirement for anyone to provide evidence of the immigration status to the employer before they can work. But obviously employer do not want to take that, so you always have to go in court to argue with that, but you don't want to end up in court with your employer because the only thing you want to do is simply to work really. And the other point is that the employment the employers, of course, they have to establish statutory defense. So they will ask you for this evidence because there is a penalty involved with that in case the employer and you did not have the legal right to work. But again, whether they fear that they're going to be fined by the home office or not, it's irrelevant. They still have to comply with the law. And that sometimes employers are really, really confused and they decide that, well, because we can be fined, so we don't want to take the risk to employ somebody who does not have the legal right to work, even if it's not the case. So for EU citizens, it's going to be really, really challenging because you only have one process to prove your right to work. And when the right to work check does not necessarily fail, but when the system fails us EU citizen, then it's impossible for us to be able to challenge employer. Of course, as I said earlier, you have this online checking service where the employer can contact the home office and get that information, but it may take quite a long time. And during that time, you don't have a work. So these are the kind of challenges EU citizens will be going through after the 1st of June. Oh, sorry, the 30th of June. But all these problems we have experienced that. Non-EEA has experienced that. And at the beginning, I said I was an EU citizen, but I was a Black EU citizen. And Black EU citizen or EU citizens from BME community have been experiencing these issues since 2008. So there are ways of preventing all this from happening, but action needs to be taken. People need to be educated as we are doing today for you really to understand what the issue is. I'm going to stop sharing my screen now. There you
Okay, fantastic.
go.
Thank you so much, Aka. Does that conclude your presentation, or did you want to add anything else at this point?
Oh, I'm really sorry. My camera was off during the whole time.
No, we saw your presentation, so it's all good.
No, my okay, that's cool. That's cool.
We saw your presentation, so that's all that matters.
Okay.
That would be terrible. No, I can see you. I can see you. That's great. We are still recording. Did you? That's the presentation. Thank you so much for going into all this detail about the different ways in which there are problems to be found. We've got a good 40 minutes. I just want to, for the recording, summarize here. Our contact details are euss@caliverpool.org.uk. The phone number is 0151 522 1725. And of course, Migrants at Work are also online. It's migrantsatwork.org. I don't think there's a UK on the end. I think it's just .org.
Yeah.
They are, of course, also on Facebook and Twitter, so do give them a follow. It's also possible to get advice from an employer's point of view. So the aim that we have is to educate, and I think that's an aim we share, to make sure that people can apply the laws correctly and not fall foul of them. So thank you very much for this. I'm going to stop the recording and then we can move on to the questions and answers. And it would be lovely to see you all then, so that we know we're not talking to the ether. So please bear with me one moment while I just stop the recording.